Hello everyone, I'm Matthew Karakalakis, founder of AMK Law. Today we're going to share with you an excellent video with one of my favourite mentors, Fran O'Brien. We recorded this interview on SBS NITV radio. Hope you enjoy it. She's got some great tips, she's got some great lessons. Hope you get as much out of it as I did. Thank you.
Welcome back to this episode of Tell Me Law, episode 3. In the first two iterations, it was just Matthew and myself demystifying some legal challenges and myths. In this episode, it will be a three-way conversation with me in the studio. We've got a guest, Fran O'Brien QC. Now, Fran O'Brien has practiced in employment and industrial relations for 30 years. She's an expert in discrimination law. Fran O'Brien's recent activities include membership of the Geelong Inquiry Commission and chair of the Ararat Commission of Inquiry. Fran acts largely for applicants but has also acted on behalf of significant corporations and government departments over her career. Also in the studio, we've got Matthew Karakalakis, who I don't need to introduce anymore. He's a principal lawyer and founder of AMK, a 100% Aboriginal owned and 100% Aboriginal operated law firm based in Melbourne. Welcome to ITV Radio.
Hello Bertrand, thank you very much for having us here today.
Yeah, I'll first fire up a question to the two of you. Besides being in the legal profession, how do you both know each other?
Bertrand, would I just be able to say, first of all as well, just like to pay our respects to the traditional owners, Wurundjeri people, and the elders, both present, future and past, and acknowledge all the fantastic cultural and significant contributions that our elders have made to our country. That'd be fantastic.
Thank you very much, Matthew. Again, you've got me in the wrong because we just introduce our programs here, and one thing that's very, very important is just paying our respects to elders past, present, and elders to come. Thank you very much for reminding me of this very, very important duty.
Thank you, Bertrand.
Now, our first question again, how do you both know each other besides being legal practitioners?
Yes, so Fran has done some work for me and my law firm since we started in 2014. Through that work, Fran helped me a lot, and I learned a lot about litigation and law through Fran, and she became a mentor of mine as well.
Wow. A mentor. And Fran, because since we already know Matthew, I've been working with him for a few weeks now, producing this Tell Me Law episode, Tell Me Law series. What are some of your most enjoyable career highlights? Because you're one of our most distinguished guests today, but also one of the most distinguished lawyers here in Melbourne.
Oh, well, I wouldn't go that far, Bertrand.
I've read your profile and I've seen so many of your feats, so I didn't enumerate them in the introduction, but I've seen so many things, and distinguished you are.
I'm about to retire, but I have had a very, very enjoyable time in my career as a barrister, because that's mainly the work I have done. I was a solicitor for a short time early on in my career, and later in mid-career I had 4.5 years in one of the big city firms. But 30 years as a barrister is what I've had, and it's been a very, very enjoyable time. Being a barrister is a very exciting thing to do. If you any young listener out there, if they're contemplating work in the law, that's being a barrister is something they should seriously think about. It does involve a lot of work, but you get a great deal of satisfaction, and the satisfaction is after the hard work comes, pretty hard and fast after a success in court, whereas practicing as a solicitor tends to be hard slog with the satisfactions coming over a much longer period of time, I think. So winning cases is something that is always a highlight for a barrister. I don't like to lose cases. It's a low light for a barrister. And I think the other very big thing for me is the satisfaction and gratitude of clients that I've had, and their expression of their gratitude to me comes in all sorts of forms. It's often just a case of, thank you. Often it's a case of a very large bunch of flowers, and it's very gratifying indeed when people express their satisfaction with your work, even when you've lost. And that has happened on occasions.
And Fran, you've worked for many years in the discrimination, employment and industrial relations areas. What is it that interests you most in those types of legal matters?
That's an area where you're always dealing with people and their lives. And I find that tremendously satisfying. Again, anybody contemplating a career in the law, this is an area, if you're interested in people, that you will get tremendous satisfactions out of. These issues are often complicated and often difficult, so you've got to have a breadth of skills to deal with all sorts of people, both on your side and on the other side, whoever that might be. I always wanted to work in this area. It was, many years ago, very hard to break into, but I had some lucky breaks early on in my career. I was doing, in the discrimination area in particular, where nobody else wanted to do the work, I was prepared to do it. And I did a lot of discrimination work early on, and I did a lot of misconduct and disciplinary hearings. And that sort of set the scene for me to go on and develop a full practice in this area. My colleagues, who are all commercial lawyers, that is my colleagues in chambers who I share my chambers with, they often come in and say, "Oh, Fran, what are you doing today?" Because they know it will be something of interest and interesting. And that's very different to the commercial law, which tends to be, in my view, rather boring.
But commercial law, that's the law that every aspiring, successful lawyer, when I interview some students in law, and their dream is IP or corporate legal practitioner. They want to be, that's the space they want to be in.
They might find out the hard way how riveting that is. Can be very dry indeed, I think. The IP, which is, people think that's really interesting, that can be tremendously dry, despite what other people say, on my understanding of my IP colleagues.
You touched on the point about your practice areas in employment and discrimination matters being about the people. And I think that's something that I've been inspired in seeing you work, how you very much in your career have been about the people, which I think is something that a lot of lawyers can learn a lot from.
Yes, look, it is about your clients, and the critical issue I always think is, and this is often overlooked, I think, you know what the case is about. You might know the law, but you most definitely need to know what the facts are. And I've often encountered situations where people don't know what the facts are. You cannot properly act in any matter, be it commercial or industrial or anything else, without knowing all of the facts and all of the details of the case. If you then have the capacity to apply those facts and details to the law, well, you'll be a very good lawyer. But I think people overlook how important facts are.
And we have a lot of Indigenous listeners on this program and on Tell Me Law, and in particular we have a lot of young lawyers listening to our episodes together. Just say there's a young lawyer that might have just finished at law school, listened to this program, and you were to give them sort of some words of wisdom and advice, what would you say to them?
Well, one thing, recognise that the law is a very hard taskmaster. It's hard work, it's very hard work. But if you're prepared to do the hard work, success will come, there's no question, because that hard work will be recognised. I've always said the law is 99% application, 1% brilliance. There's a lot of people walking around thinking they're geniuses. It's no substitute for hard work, and never will be, and it's no substitute for success. No, and I've been around a long time. I've seen a lot of success and a lot of failure. 99% of the success is hard work, in my view.
That point about hard work, I think, is an excellent point. That's a really great principle that can carry across other industries as well.
And the industries, well, there's no shortcut. You have to put in the hours, you have to put in the time, and at the end of the day, that's when practice makes perfect. As some people say, I don't know if I got it right, but because I'm more French speaking, sometimes when I translate items in another language, I get it the other way around.
Mm-hmm.
Practice makes perfect.
Yeah, practice makes perfect. It's a great catchphrase, if I may say so, Bertrand.
Mm-hmm.
As a barrister, you learn techniques for effective presentation of a case, both in terms of presenting your case and cross-examining witnesses and getting evidence from your own witnesses, cross-examining witnesses on the other side, and then summarising your case. And those techniques are perfected by practice. So going into court and running those cases, you can rely on those practices to get you through, and the more you do it, the better you are at it, undoubtedly. It also takes judgment. You must have done the work and have the facts in your mind ready to trot out for your use. But getting into court and doing it you just see it. I mean, I don't consider myself to be a particularly fantastic barrister, and you do see brilliant people who are naturally brilliant, and you do see them. They are wonderful to watch. They can think on their feet. Very, very good barristers. But if you're prepared to put in the hours and practice your profession, you can be a very effective barrister, in my view.
What are the most important leadership lessons you've learned through law, and how has it helped you?
I suppose there's three. The first I've already referred to, which is, you've simply got to do the work. And as the leader, whether you're alone in court or whether you have a junior or whether you are the junior with a leader, you must know what the case and all the details of the case. The second thing is, I think everybody makes mistakes, and most mistakes can be rectified. People lose their cool, blow their top. I've done it. I'm no saint. But most mistakes can be rectified, and they really ultimately don't matter much, really. And three, I think the consequence of that recognition is that stay calm is the other leadership thing. As the leader, you've got to be able to stay calm, take the tornadoes as they come through, and take the good times as they come through, and make the most of both the good and the bad.
Are there any interesting stories from your career that you can share? Maybe some, because I'm always curious when I come across someone who's in the legal profession. I tend to try to get the details, but of course you won't give me confidential information, because as a journalist, always curious, want to know
This is your chance, Bertrand.
what's the little trick that you use in them? How did you trap them? How did you, something that you could share with us?
I've been thinking about this, I should say. One always endeavours to settle one's cases if one possibly can, Bertrand. And as I'm sure you know, something like 95% or more of cases settle. Very few cases run to trial, what we call run to judgment. Some cases start and then settle. Some cases run to judgment. I was involved in a case which is on the public record, so I can speak of it, which is I've done a lot of sexual harassment matters. 99.9% of those settle. This one is known as the Rivers litigation, and this was a case where my client alleged certain sexual improprieties on the behalf of her boss towards her. And during the course of bringing that litigation to trial, we became aware of two other former employees of the same employer making the same complaint some 5 years and 10 years respectively before my client's employment. Now, sexual harassment cases are always word against word. I said, he said, she said. Sexual harassment's not usually conducted in public, as you might imagine. So when we became aware of these other two complainants, we interviewed them separately from our clients and took what's called a proof of evidence from both of them. And their proofs of evidence were astonishingly similar in the conduct that my client complained about. So we sought and obtained permission from the court to use that evidence from the other two employees to demonstrate the credibility of my client's complaints. Now, this is a technical process. It's very rarely used. It's called similar fact evidence. It's got another name now, but it's essentially called similar fact evidence. It was my view that my client would be believed in any event. She was a very credible young woman, but having obtained this evidence, we thought that we should use it, and similar fact evidence is admitted into the process of the hearing of the matter at the initial stages of the trial. And so that occurred in this instance. So we began this case on the Friday. My client gave evidence. She was cross-examined by counsel for the employer, and then the statements of the other two employees were then put into evidence as documents, and then we went through a process with the court as to whether they would be admitted by reference to the evidence that my client had actually given. And the judge wrote a judgment. This was on a Friday. She wrote the judgment over the weekend, and on the Monday she set out in her judgment all of the matters that she was going to admit in our favour to support our client of the content of the evidence of the other two employees to give credibility to our client. And that's in a judgment of the federal court. You can go and look at it. And it was at that point that the employer decided that he wouldn't go any further, and the case settled. So that was very unusual, but very exciting and very gratifying process, because it meant that we had a number of other witnesses to call. The case would have gone on for at least another 10 days if we had to pursue it any further, and we were able to settle it on very good terms, obviously, for my client. I can't obviously say what, but good terms for my client, and most satisfied. So that was one of the highlights of my career.
Wow, a successful one.
Yeah.
How do you find those other witnesses? Because
it was sheer luck, Bertrand. It was sheer luck. It was just luck. It just sort of turned up out of the blue. For reasons I can't even now remember how they did, but it was just sheer luck. And none of them knew one another. They'd been employed at completely separate times. The first one, the oldest employee, she'd been employed there some 10, 15 years before. It was a long time ago, but exactly the same sort of conduct was doled out to her as to my client some 12 months before these events.
And one of the, I think, interesting points that you explained to us, Fran, is the judge's willingness to point out the similar facts, and then the way that encouraged the settlement to occur.
Yes.
So early in the process.
Yes.
I think that would have assisted all the parties really, but also your own client in those circumstances, to be able to settle the case early rather than wearing all of the difficult emotions and even costs that can go into the full trial.
Matthew makes an excellent point, yes.
And are there any cases where you go home and just keep ruminating these things is going on? Because we do get sometimes situations you feel, well, have I done enough, or should I do this? Are there cases where you go home and just can't settle because you feel something, there's a gut feeling that something went wrong or something should
Of course. Of course, Bertrand, and I don't think any good barrister would not have had that experience on a very regular basis. I always say to my clients in settlement negotiations, if you accept this amount, or if you decide to give this amount, if you're giving over the money, you will leave the settlement room, with a room where you've signed up to the finalisation matter, and on your way home you'll think, I've paid too much, if you're the employer. If you're the recipient, the employee of the amount, you will on your way home think, it's not enough. And if that's what you're thinking, it's usually the right amount, in my experience. People always think it's not enough, and they always think they've paid, the other side always thinks they've paid too much.
That's always it's never enough.
No, look, things do go wrong, and this is not it's not a perfect game by a long shot, and for lots of people, the risk of losing presents a very important consideration, because they cannot afford to lose, especially individual employees. So the pressure to accept an amount which may not be consistent with their expectations or even their proper entitlements is very great for that reason. And as a barrister, you need to temper that consideration against the complete sellout of the client. I mean, you can't just leave the client accepting chicken feed because they're concerned about this risk. You have to advise and say, perhaps we might go on to the next step before we accept this amount, take a few more risks, and then perhaps settle at a later stage, without putting their homes or their funds or their person at risk of an award of costs. I mean, I take the view that you must be able to assess a case carefully and realistically, so that you don't delude clients into thinking about what the sums of money involved are, and you don't delude them about the risks should they proceed. So if I think something is a loser, I don't have any hesitate in telling people so. And same with employers. If I act for an employer and I think they should pay, I tell them so. And if I think it's a loser for them, I tell them so. And I think that sometimes, it's my view that employers often take the view that employers often think that they should be told what they want to hear rather than what they need to hear. And that's a proposition that is also true of employees. You have to tell your client what they need to hear, not what they want you to tell them.
Employment law, which is one of your specialties, is an area where I'm always critical. On my side, I always think there's way too much power on the side of the employers and less power to the employees. Because as I can see historically where we're heading, as just an observer of what happens in society, I see that the bargaining power is shifting way too much on the employer's side and less on the workers and employees side, less to the little people and more to the big boys in society.
You've raised a controversial issue, Bertrand. In some areas, I think your position is true. I'm not suggesting for one moment that employees are in the box position, but it's a controversial area and it's complex. Perhaps too complex for me to comment on in this program. Certainly acting for an employee, they don't have the means to have a big argument. If an employer wants to have a big argument, whether they've got a good case or not, they have the means.
And the time on their side.
They have the means on their side. Good employers settle matters early because they don't want to waste money on lawyers. There's no doubt about that. But you'll get the occasional maverick employee who'll just go for broke and make life hell. But But by and large, I'm inclined to the employee side of your comment. You're probably right. But that's the role of the independent bar, of which I'm a member. We are there to keep the business, the relationship in balance, and not have people just run over by overbearing employers. That's our job.
And because you're about to retire, what are your future plans?
Well, everybody will laugh, but I'm the only retiree in Australia who's not going to travel. I'm going to bake cakes, play golf. I'm interested in doing a bit of a course in poetry at Melbourne University. Things that I go to concerts, things I haven't been able to do. I mean, one as a barrister, one is very, very busy. Going out during the week is very difficult because one has to get up in the morning early and get to court. And so all the things that I haven't been able to do for many years, I'm going to do.
Reading?
Reading, yes. And reading.
What's your favourite book? I'll tell you my favourite book in a moment. It's about lawyers. But what's your favourite book?
I hope you won't think this is true. Look, the most formative book of my career was the book by Simone de Beauvoir called The Second Sex. It was written in 1947, and I obviously didn't read it until well into the late 60s. It was in my local library. I grew up in the country. And when I took it off the shelf and took it to the librarian, because I was still a young woman, 16 I think, I said, I want to read this. She said, oh, I'd have to speak to your mother about that. And my mother was a very broad-minded woman, and she said, oh yes, that's okay, you can read that. And it was it's an extraordinary book now, and I know that when people read it now, young women read it now, they are amazed by it. It explains things. It explained the role of women in the world and how they could take their place in the world, and it was an inspiring book for me.
Favorite books, it's not just one book. I'm a fan of history, and my favorite books that have actually made me get interested in English literature and reading more and more English books, it's about actually corrupt lawyers. Written by a non-lawyer, by John Grisham.
Yes.
I like reading his stories, and his stories about how people get tricked into legal situations, the way he explains, maybe it's in an American context, but how corrupt the system can be, and how some lawyers can be really unscrupulous.
Well, it's interesting you mention that, because there is a beautiful book that I read recently about, and your listeners, your Aboriginal listeners, community listeners will be interested in this. Marshall was a Supreme Court justice on the Supreme Court of America. He was also a barrister for NAPA, which was the African American Association. And he used to be sent to the South in the 40s and 50s to defend black men and women who'd been falsely accused of crimes. This was extremely common. And of course, this is redneck country, and if he turned up, he all sorts of things. You know, as he would be driving into town, his car would be shot at, and there was a series of attempts on his life. You know, because he was going all over the South doing this. Someone has recently written a book about those experiences he had, because they were using these cases to expose the corruption of the Southern justice system, and they were taking them on to the Supreme Court of America. So they had to have this brilliant young barrister, effectively, a brilliant young lawyer, to make the points at the criminal trials. And that was a tremendously inspiring book about how you deal with corrupt legal systems.
Yeah, none of the reason why I like those books is just because you never know how a case is going to end up. There's always a twist. It's like the movies, but the movies are so quick and you miss out on a lot. These ones are detailed, and then, well, you think, like, just like in your case, you found these witnesses who were unexpected. Case solved within a weekend, whereas it could take years and years, and you never know how it's going to end up. It could be the other way or one way or the other. So it's really, interesting. Maybe Matthew, I didn't let you put in any questions.
That's fine, Bertrand. I can see that you really enjoyed what Fran had to share with us, and that you asked some fantastic questions. So
We just kept talking, and could go on and on and on and on. Well, Fran O'Brien, thank you so much for taking the time to actually pay us a visit But before I just close this conversation, I think it's more appropriate to let you give us maybe a final word to share with us. Maybe a word of wisdom to us youngsters who are aspiring to achieve what you've realized in your career.
Oh, well, they should go
Not
out.
youngsters, but
That aspiring young Aboriginal community. I mean, look at Deborah Cheetham and, the Eric Avery, the musicians, the Aboriginal musicians. I mean, aren't they fantastic? And we've got some Aboriginal lawyers, and we need more Aboriginal lawyers. So they need to get on their horses and get into the law schools and come and show us how it's done.
Fantastic. Fran, thank you so much for what you've had to share with us today. And I think that your words have been very inspiring. And thank you for the input that you've had in my career, and thank you for all the great work you've done, for many, many people, including Indigenous people and Indigenous communities. It's been fantastic to see your contribution. So.
Thank you.